mic though.
Good morning.
Good morning.
We'll kick off our session today. I feel like that's really loud. Okay. I'm just going to repeat, Karen Perez has to leave at 11, and then you mentioned that your member will be arriving in a little bit. So we were going to start, I let you know about lunch.
Yes,
That's going to
thank
be
you.
arrived 11:30, 11:45 in that room. And you had mentioned you want to take a caucus after we present Article 8 and Article 12, correct?
Yeah, and we only actually would need a caucus if the printing wasn't done ahead of time. That's just more of a like buy some time, so we're not all just sitting here twiddling our thumbs. And Michelle is on it, so we might not need that.
Okay, appreciate it, thanks. Okay, so we need to get 8 passed out. It is.
Watch out for the legs.
Yeah.
Yes. Oh, I tore it from the stick.
That's fine. Here.
Does everybody have a copy? Okay. So I'll go ahead and get started. We're going to share the responsibility of this article with several of our members. Just wanted to go through the first part. We, accepted all the way throughout the bargaining unit members, so I don't need to address that each time. Wanted to go through with you the part on evaluation and conferences. So for 2B, you had suggested PFI. We had actually looked at that and the statute, and there's language in the statute that it actually doesn't use an acronym, but they speak to the fact that it's a program of assistance for improvement. And so we're suggesting that we change it to PAI for that piece and keep the POA for the other piece.
And Janine, if I could just chime in, I think my bigger concern, so if I looked at your 2B from last time, you had changed the language, so it looked like it was going to say plan for improvement. And I hesitated a little on that just because the statute does use the term program of assistance for improvement, so I wanted to make sure we were talking about the same thing. So I was a little bit wary about using two different names there. Yeah, I'm less concerned about the acronym personally anyways than I may have made the comment, why do we even need to have any acronyms? But then it was clear that you use them, right? I mean, so, but I worried about just going plan for improvement because it wouldn't have matched up with the statute then. So, thanks.
Thank you. And then for C, we accept what was written down there. And I'm going to turn it over to Matt to speak about.
Hey, Janine,
Yeah,
sorry, before you move in, we do have differences in C.
Oh.
So they have I believe in the association's last proposal in that last sentence, this provision does not apply to members who are on plans for improvement regarding the same performance issues more than 6 academic years prior, and we're proposing a 10-year window.
My apologies.
Yeah, nope, thank you.
So we're on to D, citizenship and academic freedom. I think we are already in agreement on paragraph 1, citizenship. There, paragraph 2, last time we discussed this, there was some references around our proposal to identify guiding documents here as an indicator of lack of trust in member professional judgment. I just want to be clear here that it's not about any lack of trust. We have a lot of trust in our members, but there are certain things that we have to make sure happen consistently across the system. So we're not accepting the language to remove those references to those documents that should have consistency across our system, and we're proposing that we stick with the references to the documents listed there, which are both district policy and then state and federal standards. And I think that's the only thing in paragraph D.
Yeah, and if I could also just as we're walking through this, we did accept some proposed changes you had, like in B, evaluation of students, for example. I don't know, Jeannie might have said that, but I might not have caught it. So we picked up your language, so we should be in agreement on B now. And also C, adverse criticism of bargaining unit members. We may have been in agreement on that section. I don't remember the complete sequence of events, but those two sections now should completely be the same language in our two proposals. Sorry. Yeah, you guys had proposed in C, provided such, I'm sorry, in C, my mistake. In section C, you had added the language, this shall not be construed as excluding representatives of the association. And we picked it up and we said, provided that such right of representation exists, that is, it would still be our intent that this wouldn't expand the scenarios in which people have a right to representation. It would still be those meetings that they've always had the rights. And we felt like what you were wanting to provide there is that when we say things are in private, it doesn't mean that your rep can't be there. And we agree with that, assuming it's a meeting that you always had a right to a representative in. So thanks, Susan. We do have a slight difference there. Sorry about that.
All right. I have the next section on E. And I think on E, we are pretty close to agreements. We just have a couple clarity items that we've changed in ours, starting first and notably with the intention of the use of physical interventions is really to prevent an injury. It's not to keep order. And so we really wanted to provide some clarity in the language around that particular topic. And so you'll see initially we changed quell to stop, just as I think that's clear and simple language to help identify that we are preventing or stopping physical injury to self or others in the use of physical interventions. The rest of the wording is the same. However, we added a line at the end that we feel is supportive of making sure that everybody understands that we need to follow the restraint and seclusion guidelines that's set forth annually and delivered through the vector training so that guides our responses when physical interventions are necessary.
And I think I'm up. Yes, okay. And I am doing E3, property damage and harmful acts. And for the most part, we've picked up your suggestions really around bargaining unit member. And some where it states a person or other intentional acts of destruction. You had removed intentional, but we kept it. And moving towards the bottom where it says this language, the last sentence shall not be constructed as pertaining to accidental damage from students. We left that there. What we did not accept was the sentence before that. This language shall apply to destructive acts undertaken in a state of dysregulation regardless of intent. Our biggest concern there was the word dysregulation, as it is very subjective what dysregulation might mean from one member to another. And then moving forward number 4, reporting property damage and harmful acts. We just reworded that to mirror the heading in number 3. And again, we accepted the bargaining unit member where that goes and most of the wording there, except we didn't accept B. But we did add a sentence at the bottom of A where it says bargaining unit members shall also report cases of physical harm against their person via the work injury reporting system maintained by the district. We already have a system to do that. Staff know where to go to report injuries caused either by accident or by a student. And I know you wanted a report or administrators and teachers to be trained around that. That already happens. via vector. We agreed that it's part of pre-service. We just remind staff where to find that. And safety committee takes care of creating a list of all, they collect all of the reports. So every building has a safety committee, and they print reports and keep the administrators informed and risk management of all of the injuries that happen at every work site. I think that captures everything.
Thank you, Veronica. For the next two sections, F and G, we just accepted bargaining unit member and everything is the same. And so H is Brian.
Great, thank you. Excuse me. So just to refresh recollection on where we've been and what we've been talking about in H, I know that this is kind of a repeat for most of us, but this was language here in our non-discrimination provision where we had at the tail end of that the language that essentially if you filed a complaint in federal or state court, it would end your grievance, and we needed to take that out. We both recognized that needed to come out. I think, our ongoing concern here, we had previously proposed simply that this section couldn't be grieved, and our rationale there being, we have extensive other legal remedies that exist when we're talking about very serious situations where discrimination is alleged. What our real worry, I think, is having to litigate twice. And so in our revised language, grievances could be filed and they could go to the board level because then there would be an opportunity to handle it internally before it had to get escalated to the point of litigation. But at that point, the grievance process would stop and the court system would take over. For us, that avoids, it accomplishes two things. Number one, it avoids the district having to arbitrate it and then potentially defend itself in court. So kind of a double jeopardy type of scenario. It also keeps those claims ultimately, if they can't be resolved at the lowest level, in the court system, which we have, I think, a little more confidence in when it comes to a claim as serious as a discrimination claim. We view those claims as being deserving of the rigor of the court system. Our arbitration system, for those of you who haven't gone through it, it's a layperson, it's not a judge, or it's just who we get. We choose off a list of people. They don't necessarily have experience in that field. Their decisions aren't subject to any sort of appeal. So it's a great system for handling kind of routine contract violation scenarios. It's not a great system for handling legal claims, from my perspective anyway, like discrimination claims. So again, you see a revised proposal from us here that wouldn't completely bar it from the grievance process, would let it go through the board level, and then we would prefer it move over to the court system at that point. Thanks.
Okay, section I, physical environment. We are accepting the language and honestly a shared interest in which the district will comply with state and federal laws and regulations pertaining to the environment concerns, workplace safety, and maintaining a healthful environment. We are also accepting most of the second language proposed, in which the site administrator or designee will communicate with the affected staff member within 2 weeks of an update of what was reported. But thereafter, we will share what information and updates are available with that staff member. And until a resolution, of course, is reached, which in itself would be an update. The last part of that section, number 1, we are accepting the spirit of what was proposed, in which it is important for whenever there is a study commissioned by the district for the member who brought this concern forward to be informed. And in addition, when something like that happens, for all staff members to be informed. So we're accepting that component. And when we inform all staff, we're also informing our union reps, which in turn informs our association as well. And we left the word as appropriate. There's often times where there is some type of a sample that is taken for a study with a specific location within a classroom, and therefore the affected member and a union rep should and will be informed, but doesn't necessarily impact all staff. But that's something that we can collaborate and talk with the people affected if that's something that's necessary moving forward.
All right, and the remainder of that article, I believe we have a common desire and interest in preventing heat and illness injuries and making sure that staff and students are safe. And we continue to look to OSHA for the guidance around that, as they are the governing body and truly the experts in that particular area. And so we are rejecting 2A through C. Again, stating that the opening statement in number 1, that the district will comply with state and federal laws, really encompasses that, as OSHA gives guidance around heat and illness prevention and mitigation. And we have those guidelines to share if anybody would like to see those. I know they're accessible to everyone on the internet as well. But again, we will continue to follow the OSHA guidelines in responding to concerns around heat illness prevention.
Okay, the rest of the article, K, we'd already accepted the language, and L, we accepted part of it, we changed it to be comparable to, similar to Article 6. And so if you read through that language, it's mirrored there. Basically, we're saying that the personal life of a bargaining unit member is not appropriate concern of the district unless it interferes with the bargaining unit member's execution of their professional duties, where performance, school operations, student relationships, statutory responsibilities, or is otherwise related to their work. The next subsection, M, evaluation, we're not accepting the language there. Basically, we don't want the contract to dictate what we do for evaluations. We follow processes and trainings, and we also are constantly in communication with BEA with regards to any kind of a plan for an employee working in tandem with them. Is there anything else our team would like to add?
I think I would just add that this is an area of great responsibility in terms of management, and we want to make sure that we are following the provisions of the law for due process for our employees, but also that we have the flexibility to support our employees in the ways they need to be supported. And so some of the provisions in your proposal could be constrictive and not allow us to support people with the flexibility we may need to. And also, just to echo what Janine said, we do have a collaborative relationship and understand that the communication with the union when we have someone who is receiving this kind of support is a very important part of due process and supporting our employees as they deserve.
Any questions from your team about Article 8?
Not at this time, thank you.
Okay, thank you. Well, we'll move on to Article 12 and Appendix J. Okay, wait. All right, seems like everybody has a copy.
So I will be guiding us on a journey through Article 12 and also Appendix J. It's lofty going between both articles, the appendix and the Article 12, but I'll try to go in a cohesive fashion so that everybody can follow along. The last time we received your proposal for Article 12 and Appendix J, your intent was to move some of the articles or the provisions from the MOU to the article. And so our team met and we've tried to follow suit with that. So you'll see that we are transitioning some of the information into Article 12. So with that, I'm just going to start with Article 12 and go through that, those pieces. So the first piece here, you'll see at the top, it talks about articles that are held in abeyance. So we have, with our new proposal, it'll be 12B through F there in this Article 12. The first section with the definitions, I think we agree on 1 and 2 on the definitions here. On 3, we have gone back to our original proposal where it talks about a transfer, which is a change in work site. You had added on there that a transfer would also include movement from grades K through 5 as far as an assignment of more than 2 grade levels for classroom teachers, which would constitute a transfer. We don't believe that that is a transfer. Transfer is from site to site, work site to site, so that we are rejecting that language there. The second piece of your sentence that you proposed about a bargaining unit member may be involuntary transferred no more than once every 3 academic years. I think we've spoken to you the last time about that, what that would cause, like a ripple effect could lead into a layoff if our hands are tied in who we can and cannot transfer at that point. And our goal as an employer is to make sure that we have assignments and we employ all of our educators. So we are rejecting that due to the fact that it may cause an unintended layoff, and that's not what we want. Following through with this, B and all of the other sections all the way to F are dormant. So in this particular article, we'll go down to assistance, which is G, the new G.
Hey, Erica, can I
Yeah.
just stop you? There are some
Please.
places, I think, in current language like I, where we didn't adopt the bargaining unit member instead of employee. I think we're
Yeah.
fine making those changes. I think I just overlooked swapping
Yeah,
that language out, so.
and that's a good point, Brian. So I think like for the whole bargaining unit, the pieces, we agree, and we thought like after we define all of those
Yeah.
and make it right, so.
Thank you.
Yeah. All right. So going over to G, which is assistance. Let's see. We have included the information, the top part talks about bargaining unit members who are involuntary transfer or their grade level or subject change shall be allowed release time. We're sticking with our current language that we have there. It's definitely a cost factor in there. So at this time, we are not going to accept your language with the proposed changes that you have to assistance there. And also, my team, if you want to chime in, please do so if there's pieces that I've missed. In the second part on number 2, there's a little wordsmithing, but I do think that the intent and the essence of what you're proposing is really captured in our proposal in 2. If a member is moving to a new classroom or workspace, the district shall transport their books, materials, or other personal belongings related to the assignment. It's pretty much the same what you have there, it's just some wordsmithing. So hopefully that will work there. Moving over to the next section, talks about number 3. You have, when a bargaining unit members are transferred into a new school, I'm just gonna go back and forth on comparing our articles. We propose that when a bargaining unit member are reassigned to a new subject area, we feel that there's a big difference there, that when someone is transferred to a new school, but they teach the same content or subject area, there's a different level of support. And it may be support around acclimating to a new building and things of that nature, but not necessarily with plan for professional development, because it's still the same core content that they're teaching. So we said that it would be when they're reassigned to a new subject area that they have not taught within the last 10 years. Your proposal was really centered around with little or no experience. And as we discussed that with our team, we talked about who determines little or no experience. So we thought that a really permanent marker of 10 years where something is very tangible that we can look and see, we wanted to propose that. So we changed it to have not taught within 10 years. And we changed the whole bottom section of may request, the member may request to the administrator for building and district level professional development. And the reason why we changed that, because if administrator is going to an educator and saying, you need PD, we need to write this down. To us, that kind of sounded a little like a plan of assistance or a plan of awareness, and that's not the intent. So we wanted all of the onus to be on the member to request and support, not that we would not help, that's our goal, and to help and support, but we want the member to initiate that with the building administrator. And that we wanted to specify which type of professional development, so there's no question about that. So we named it and said building and district level professional development for that one. The next one is trading work sites. We just did a little cleanup on the language since it will be included in the Article 12. And we started with 2 qualified bargaining unit members may express an interest in voluntary. We wanted to note that marker because there's a lot of things that go along with involuntary. In this particular situation, it would be voluntary because 2 members are asking to change in work sites. So we said voluntary transfer to trade work sites by submitting a request no later than July 15th. So I think all of those pieces are pretty much the same there. Okay. All right, and I think that is it for Article 12. Move to the MOU. All right. Okay, so the first section in there, you had proposed a lot of definitions with other operational features, and that we're going to reject. For the mere fact they're not just true definitions, they have a lot of operational features that are in there. And so we are going to propose and go back to our regular language where we talk about the district and the job expo and the intent of that MOU there. The definitions have been moved, so we don't address those there. The next piece is in B, you had preparations for assignment. And as we discussed with our team, didn't quite get at what that is. And so those pieces are really around staffing preparation. So we just changed the title there to staffing preparation. You had on yours 1 and 2, you had no later than January 15th of the year. We'll do a virtual staffing preference survey. That will be discussed in B2. So we did say that we honor and we want a staffing preference survey, but the dates, and you'll see throughout this MOU, we talked about dates being problematic in this because there's so many factors that go into everything else as far as preparing for this particular part of the year, assignments. And so the dates fluctuate so much, but when we have a definitive date in the contract, it creates a lot of problems with us trying to follow this linear fashion and acknowledging those dates. So you'll see that we've removed some of the dates and put some markers where you will know where those actions will take place. So 1 and 2, and the second one is really the same thing. Mike has talked many times about our financial reports that come. They're not in this fashion that would allow us to present this information around February 1st. Those dates just won't work for us in that fashion there. Let's see, so I'll go to this one. When you talked about, I am at number 3 that talks about the staffing preparation when we talk about review job expo timeline, including tentative timeline for placing unassigned staff. There we remove the after the expo because we are committed to placing staff before the expo, and you'll see that further in the MOU. And then I also want to note, we talked about this the last time, we've replaced the word hard to fill with priority. So that is a change there. The next piece is number 4 that you have there, and you talked about no later than February 1st, 22nd each year, we'll have elementary class size committee and secondary forecasting will finalize their recommendations. Again, the date that you have in talking about finalizing things just would not be good at that stage. And also when we talk about our class size committees, They are advisory to the principals about class sizes and things of that nature, and so we want to maintain that right to have them as advisory. And then for the transfer pieces that you have at the bottom of 4, that, we talked a great deal about that and how it would create a lot of, disharmony in the buildings if we have a position that's moved and then you're saying who wants to volunteer and things of that nature. And that is really for the staffing preference survey. We ask all educators to submit their thoughts and wishes. If there are movement, if there happens to be movement throughout the year, administrators will go directly to the staffing survey and look into see what members have said. And always welcome to submit an additional staffing survey if there changes, if their preferences change throughout the staffing process. But we would look to the survey for that information from your members. Number 5 that you had here, you talked about prior to initiating the Job Expo, we'll hire licensed temporary bargaining unit members there. We have addressed that in our B here, and it's pretty much the same, except we ended with a unit member designated unassigned there. There are a variety of reasons why a member would be unassigned, but the main point is that when a member is unassigned, then that wouldn't be given to a temporary employee. So we wanted to end it there with assigned. Let's see. I think 6, we rejected that language there. And again, with the March 15th marker, it's too early to communicate that particular information there, and that's why that was rejected. So we're moving on to C, which is the Job Expo. Definitely the district will offer a yearly internal expo. We changed, you had members there, we changed to certified bargaining unit members because we want the expo to know that they are for certified bargaining unit members there. The next one you had, number 1, with prior to spring break. Again, we've discussed how that information is just not readily available at that time. So we provided, and we're returning back to our language of before the official start of the general external posting season that we would hold the Job Expo. We've added some markers in there that talks about probationary or contracted because we want all members to know that the Job Expo is specifically for probationary and contracted educators. We've returned to our proposal of the 5 calendar days. We had a Job Expo not too long ago, and the positions were posted for 5 calendar days. And we feel that worked well for many people. So we want to retain our right to have that for 5 calendar days. Number 2, that's going down there, at least 5 calendar days to the beginning of the Job Expo. And that's where I talked about assignments. We've added that all members will be notified of their assignments. The year before we had the expo, individuals were not notified of their assignments. This year, they were notified before the expo, and then that gave them the opportunity to participate in the expo if they so choose to. And so that was a cleaner process we felt this year. So that's our intent to moving forward, to make a clean process for Job Expo is to notify assignments before it actually is facilitated. All right, and let's see, moving on here. Let's see, during the Job Expo, we did note again probationary contracted bargaining unit members who were involuntary transfer because it is assumed that the Job Expo has already happened. Will be given, or assignments have already been shared. Will be given involuntary transfer will be given priority to interview for vacancies with matching areas of licensure. Currently, the Job Expo is open to anyone, involuntary, voluntary transfer. But if we were ever to get in a spot where we needed to address that, we wanted to keep that in there. So like if we needed to prioritize those individuals that were involuntary transferred, then we could in the expo. But because of the way that it's facilitated, we don't necessarily know that we would need to address that, but it's still in there. The next one talks about the members on the plan of assistance. We just I know you probably can't see it, but kind of highlighted that section so that when we determine the names of those, we would go back and update that section there. Okay. The next one, let's see. You have here, I'm going, the D, placement after spring break in your proposal. You have talked about a second job expo. We're not interested in facilitating a job expo, and the reason, a second one, is it pushes the timing back later for staffing and posting positions. And we've talked earlier, and I think you shared your goal about recruiting and hiring and diverse candidates and things of that nature. And so Beaverton would be later on posting positions if we were to facilitate a second round of that. The subsection of this article does not apply in that, in number 1 in your D1. We have that listed in D7. We feel that that's a better area of where it fits there, so we would do that. You have in your D placement after spring break, you have number 2, which is really known as the bounce back clause. We have talked about that, but it's in D6. I just wanted to mention about the pieces that we weren't including in there. So I'm gonna jump over back to ours. We included the number 5 that talks about a bargaining unit member attendance, and the job expo will not be taken as they are willing to be transferred. We included that one. We accepted the information about the D involuntary transfers, the last piece where you talked about unless for the reason a voluntary transfer is initiated by human resources to resolve personnel concerns. We've accepted that one. Okay, and then going down, let's go down to number 4 on ours. When you talked about a bargaining unit member should notify the transfer between schools as possible 10 days, and then except in the case of an emergency or necessitated by student or member safety. We've accepted that one. Number 5, I think, is included in the article. Going down to 6, this is the bounce back clause that we were talking about. During the period of time between February and August, if a position at the same site and requiring the same licensure as the position from which a member was involuntarily transferred. We've stayed with our August 1st, and we mentioned the reason why is pay implications. If individuals are still moving, we are really working on pay, and we want to make sure that it's stable so that we can get pay through, and we wouldn't want anybody to be in limbo at that time. So August 1st is a better time frame for that because it connects directly to pay. And then the last section of that is we accepted this provision does not apply to positions that are substantially different than the position from which a bargaining unit member may have been transferred. In that one. All right, and then your language, it's kind of a little bit of wordsmithing, but it's in the spirit of it is the same. And you talked about bouncing back to a position that's not substantially different, that the bounce back is meant for like. And then the information that you talked about, we accepted an involuntary transfer classroom teacher does not have the right to a TOSA position if a vacancy appears at their previous site. That would not be a like position. The next one is our number 7. I'm telling you, it's a definite world tour, several documents back and forth. Let's see, vacancies, number 7. You mentioned that and we accepted it, but we changed it a little bit. It says the conditions in section D, and we said except D2 because that's the reference in the survey and all members should receive a survey. So we said except D2 of this appendix will not apply to unit members who accept a job through the job expo, and such members will be deemed voluntarily transferred. We wanted to include that. I believe that's your language. We pretty much accepted that with just a little bit of changes. And then number 8, we accepted that piece. I believe the provisions of this section do not apply to bargaining unit members transferred as a result of personal action or initiated by human resources as part of a personal situation necessitated a transfer. That was accepted. All right, vacancies and transfers, or vacancies and postings. Pretty much the bargaining unit members at the top. At the bottom, that talks about this list will be posted externally. Yes, we accept that. And then on the district website, agree to that piece there. Again, the number 5, it mentions the members of a plan of assistance or awareness. We will change those terms once we agree to those there. And then the next one is just those pieces that say current are just making it relevant, a little bit of wordsmithing there. Not a big deal in the intent of the language. Okay, and the next one, bargaining unit members, I think that's from that. The assistance piece was moved to the MOU. And so was the trading work sites piece.
Erica, maybe I'll just add, that was a lot, thank you.
Yeah.
So conceptually, I think we feel like the Job Expo, we implemented it last spring for the first time. We really incorporated a lot of adjustments this time, and we feel like the initial response that we're getting from administrators as well as from our licensed staff is that it is an improved process. And so we're grateful for that, and we feel like it still is going to be a bit of a work in process. So conceptually, that's kind of where we are with wanting that to still be in the MOU.
Thank you. I think our stuff is ready, so we're not gonna take that first caucus like I had initially. We are going to need access to the TVs because we do have a brief presentation that we would like to
Access to the TV.
give. Thank you.
To what?
TV.
Not 2 to 3.
Thank you. These are just for our members. This is also just for our team. So many options to look at right now.
AirPlay or Mac Mini?
AirPlay would be just fine, I think.
Okay.
Yeah.
Okay.
Doesn't go there.
Yeah, it should be, you should be good to go.
Okay.
We'll see.
I was gonna say, cross your fingers.
You never know.
So the ones that we just passed around to Allison are just for our team right now. We haven't
Oh,
passed,
sorry.
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 Suzanne can do this.
Okay. So while we're getting the TVs ready, and before we present Article 9, I just have a few things that I wanted to say. Full disclosure, your counter on Article 9 left us confused. We felt that the latest counter has actually taken us farther away from agreement than we were before that. We also feel like it takes you farther away from your own community-facing school board policies. So that left us a little not really sure where to go with it. While looking through the article and trying to determine how we could work towards creating a counter, we were just really left with a question unanswered. Is it sloppy or is it regressive? And so we've put together just a very brief presentation to try to be very clear about the places that we're not really certain what's going on. And then we'll go ahead and present our counter to you. And this is insert Jeopardy music here.
Yeah, so you could still. Right there on that screen.
Michelle, thank you for the quick turnaround in the printing, by the way.
Then I can, if you need me to, I can send that down. Serious why they're not.
I know.
We'll see, I think this one.
Okay.
Let's try that.
What do you need?
I just need to get up on TVs. Can I just share it with one of y'all and have, like, does that work?
Problem is if it's not popping up for you,
Why would
I
it
would do
pop
the
up
exact
for
same thing
us?
that you're doing.
Well, I mean, if you want to share it.
The problem, Shelley, it's on our
It's not
OEA
on my
account.
district
Oh,
account, it's on our,
So Shelley, you could log in.
sorry.
Like if you
Looks
log
like
in,
we're
we can
taking
share
a
it to
tiny
you.
break.
yeah,
today.
why don't you, let's try it.
You take the Mac Mini though, Shelley, you have to log in.
You
there.
take the Mac.
Take the Mac Mini.
Let's see. Yeah, get close enough so I can actually see the screen.
No, like I am currently
Yeah, the
here,
mirroring's not
according
working.
to
Nice to see you.
this, but
Why didn't it work in
I did not.
There you go. Does it work in
After she said she wouldn't.
I should.
Now you have Allison doing it.
Do they have the guesses? So they do. Oh, yes. Those are the two
Screen share, Jeffrey.
Training one, training two.
Not as much listening. Okay.
She tried it and it didn't.
It said I was married, but I, in fact, was not.
Just happened in Albert.
So.
Do you want me to go get my computer?
Maybe it's like a cycle.
My students would say right now you're pulling an Aldrich because I always seem to have technical difficulties, so I'm going to report back to them. It is not user error in my classroom, it is just a thing that happens.
You didn't even show them the video.
They accept me for my shortcomings.
You were offering a cord, did they finally hear that? Karen has a cord.
Yeah.
Was it the boardroom?
I feel like I just.
Is it called?
Yeah, DOA, boardroom.
I was saying, there's like Jeffrey Klein is on there, training. It's just blast it.
Can you switch back over to Apple TV? Because it's asking me for.
Yeah, I mean, it's asking you for a code?
Let me see if I
So can we just go to screen share right there in the? But if we go to screen share, then it should pop up the code for any of
This
those.
is the Mac.
Yeah,
I have to do this. This is different.
The Mac Mini out, and so that it's,
Go to
the Mac
Apple
Mini
Smart.
out of the system, so that we could just do the. We're gonna do this, the sharing.
I just want you to know that when I'm not talking, I'm not coughing.
Do you want me to go get this?
TV doesn't say that. You just walk over.
Show you.
Shelly, when I click like screen mirror to the Apple TV, it's asking me for a code, but none of the screens.
Yeah, so none of the screens are.
How long do you want to wait for the presentation before we just try to talk our way through it?
Let's get through it.
Yeah, of course. I know.
Again, I
Okay. What's that? That's something. We're going through sources, we're going through sources. What?
Melissa, did you just switch something?
No.
Okay, that might have done it.
Oh, let's see, hang on.
So try it now. I moved it to Apple TV.
don't have my PSD computers.
Oh, boardroom 2, hang on.
Yeah, you want, the boardroom, just boardroom with no number. There you go.
963.
It's me.
Okay.
It's only available over here, but.
Well, we could probably fix that. Almost. Okay, so this screen right here is showing it.
And Shelly, it's boardroom 2, because that's what the Apple TV said.
That would be a first. Like I do boardroom 1 all the time.
We can also, Shelly, we can all look at that one, and I
Okay.
can survive.
My people just
Okay, those are gonna sleep. So it looks like for now, and just for the sake of time, I'm gonna draw your attention to this screen right here that is where it's gonna be showing. Yeah, sorry for the neck craning. That's the one that we have gotten to work. Thank you.
All right, I'm going to walk you through the presentation. I do want to just say the student code of conduct is for your reference. We are not proposing adding that to the contract. It's just for reference.
Thank you.
All right, we'll start with a quick timeline of Article 9 so far. We opened with an initial proposal on February 15th at our first meeting. BSD countered on March 7th. We then countered the following week, March 14th. And then BSD passed an opening counter with Appendix G on May 16th, and we were fairly confused on how a second counter and a fourth time this thing has been passed can be considered opening. We were wondering if that means you're wanting to discount your March 7th counter. It disappeared.
Oh, no.
Is it just my
Would you
email
like
ID?
us to say to speak to that now, or?
Can we get through the whole presentation? Yeah,
Gotcha.
thanks.
Connecting.
Let's see.
I think they tried to fix.
There we go, thank you.
All right, here we go. So our initial proposal had this language, keeping with the changing of bargaining unit members throughout. We also added this into number 1, additionally, the plan shall be. BSD's counter goes back to teachers as opposed to going with the bargaining unit members. And you accepted the language that was added there in our initial proposal, starting with additionally. Our counter then on the 14th changed teachers back to bargaining unit members, also showing that we are continuing to keep the additionally accepted language. The opening counter that came then on May 16th, we are once again going back to teachers. I get that this is a formatting thing, but it's making us question whether you were responding to our actual proposals or if you were only responding to your original language. And then you have deleted and reworded already agreed upon language. We will acknowledge that it's not a substantive change, that the meaning of what your new language is the same, but we think it's kind of a representation of the sloppiness of this proposal. and it did cause us to spend time as a team trying to figure out deleting language you agreed to previously. Is this something where we have to worry about you're trying to change the meaning now? So that's what that is highlighting. All right, in our initial proposal, we had a section that was called behavior referrals, in which we used the word referral. In your counter, you did not pick up the behavior referral section, but you did have the word behavior referrals referred to in a different section, which for us means you are okay and accept to use the language behavior referral. So in your opening counter then, you have removed language that you had in there, behavior referrals, completely from the 516 counter, and are now using behavior support request. And so in our feeling was your initial counter accepted the use of the word referral, and then you all of a sudden decide that you do not want to use the term behavior referrals. We have room clears. Again, we put forth a proposal with room clears in which we gave a definition of a room clear in both our initial and our counter. You came back in the 516 and used the definition of room clear, but you did not want to use the language room clear. And so our question was, what else is it if a member removes students from their classroom or other district space if not a room clear? And we're concerned by not using the actual word room clear is that we are not then collecting data on what's going on in our classrooms, because room clears would require us to collect that data. And if we don't want to use that language, that data is not being collected, and we can't address issues that are happening if we don't have data to support what's going on in the classrooms. And then to just kind of reinforce some of this, we're looking at the Student Code of Conduct for this year. The Student Code of Conduct, many times, I used one example of where the word referral shows up in the Student Code of Conduct over and over again, usually at the level 3 and level 4 situation. So if it's in the Student Code of Conduct, then we feel like the word is also good enough to be put into our contract. I collected many conduct plans from various buildings across the district, and I just pulled 3 here, a high school, middle school, and an elementary school, in which all 3 of those plans also use the word referral, usually again at level 3, although there were a few school plans out there that had a level 2 option for a referral as well. So again, the Student Code of Conduct is using language around referrals. Our building-specific conduct plans are using language around referrals. We're very confused and a little troubled that you were not willing to put that word into the contract, as well as it is agreed upon language in the district and language that students and parents and staff members understand, because it's been part of education for a long time. And then finally, our strategic plan, guiding what the district is doing. Under the Safe and Thriving Schools, we all agree that we want every student to feel safe. Learning can only happen if students feel safe. We know that students thrive in safe environments. The district claims that in order to create a safe and thriving environment, you will create school and district system structures and practices that build safe and inclusive learning environments. Our ask is that we have a common district referral system, which sounds like it would line up directly with our strategic plan as a district system and structure to track referrals and what's happening in our classrooms, similar to the room clear. If we have a district maintained form that tracks what's going on in room clears, this is how we can address issues that are happening in our buildings by looking at the data and then figuring out what the steps are that we need to take in order to make sure that every student and employee feels safe in these buildings. And so our final thing is, as Suzanne said, we agree on this statement above that we need a safe and an environment that fosters appropriate student behaviors. However, we do feel that we are further apart on this than after May 16th than we were on March 14th. We thought we were pretty close after March 14th to being able to maybe come to an agreement on this. And now it feels like there's been some backtracking on BSD's part around some of the changing some already agreed upon language. We feel that the removal of necessary terms is pulling back on administrative responsibilities for student behavior, and that ultimately your proposal feels like it's not actually taking our proposal into account, but that you're only responding to your previous proposals.
Susan, it sounded like you might have had a comment or a question that I'm happy to take now if you would like, but if not, we can do that later.
Yeah, thank you.
Yeah.
This was with respect to the title that said counter.
Mhm.
We had some discussion in our caucus this morning about it, and I think it was a misunderstanding on our team of what we were, even within our team, trying to accomplish. So what happened was earlier we had a conversation about sometimes when a proposal is exchanged multiple times in a session, we lose track of which one was the first one in that session. And so we had talked about putting a timestamp every single time. And I think some of what was understood in our team was to also say something about it being the opening proposal of that session. However, when I saw it in our caucus as a part of the title, I was confused as you are confused. And so we uncovered that that was where the confusion was. And so we are not gonna do that anymore. And when I saw it pop up on your presentation, it was literally what we had just talked about. So hopefully that gives you some context about that title piece.
It does. Thank you for that comment about that one particular item. We do have a counter to Article 9 that Lindsay is going to present. Yeah, after it gets passed out. There are two parts to it, I believe. There's the article and then there's, I don't know if your guys' are stapled together. They are. They're separate. There's a form, a proposed form.
Okay, I think everybody has it. All right, let's roll on. Thanks for printing this on cardstock. It makes me feel very fancy. Michelle, I'm not complaining. Like I said, I'm feeling fancy. Thank you for printing it, period. That is very, very helpful. So let's just start. Let's just rock and roll. So we're gonna start with 9A1. One of the things that the district team had removed was when administrators were receiving input on student conduct plans for buildings. We had proposed rather that input be received in writing. We removed the receiving in writing, but what we added is that we wanted administrators to make a written record of feedback from any review. We just want to have a record of what the feedback was. Whether or not that feedback is taken, we just want there to be a record of it. So that's the only substantive change there in A1. In A2, in our previous proposal, we had divided student disruption and imminent threat, and in your last proposal, you had combined those. We went ahead and accepted that combination to put those, the student disruption and imminent threat back together, and we renamed the title of that section to reflect that combination. There's not much difference from our proposal from our previous proposal. The only thing that I will say is that we tacked on to the end there just to make it very clear to our members what their rights are in terms of keeping students
safe, that the bargaining unit member may, in their judgment, initiate a room clear to prevent a further escalation of extremely disruptive behavior to imminent threat. In your last proposal, you had a section there on room clears. We moved that to a restored section on room clears a little bit later. Please turn the page. You can see the deletion there of our imminent threat paragraph, that's just because that was combined with the previous section on student disruption. In section 3, we have come back to behavioral referrals, and much like Adam shared in his slideshow, we want to make sure that we're calling things what they are, that we're not shying away from language because it's scary, and a referral is not necessarily a bad thing, right? A referral, especially a written referral, especially a consistent written referral across the district, is a way for us to recognize trends, is a way for us to identify data. We need to be able to look at data to identify where our students are struggling, what supports are our students not receiving, what supports are staff not receiving that they can provide to students, where are those pockets, and without that data, without that consistency of application, we're just missing huge swaths of it. And when we initially proposed this, I think it bears repeating, we have heard that there are administrators in schools who are saying, oh my gosh, we're doing so great on discipline, we never have any referrals, only to find out that they don't allow staff to write referrals. So this is an effort to right that ship, to be able to look clear-eyed at the problem that we have students who need help, and if we aren't able to recognize that they need help, we're out of luck. So what we have here is, again, going back to in the judgment of the bargaining member, if a referral is necessary. And again, that's to make sure that our members have the agency to determine, oh, this student is in need of a referral. It's not, oh, my administrator says that this doesn't rise to the level of a referral. I get to decide as an educator in the room with the student, I get to decide what that referral is. We do have a form. I'm gonna let Katie talk about that form in just a second. Everything else in here is essentially the same as our last, as our previous proposal. We did change, because we are bringing a form today, we did in our last proposal have the words that we will negotiate a form. Since we're bringing a proposed form to you today, we changed that to mutually agreed upon, so that might be part of this process. I'm gonna turn it over to Katie real quick to talk us through that form.
All right, if you want to pull up the paper that says Student Discipline Referral Form with the BSD logo. So this is essentially the old district referral form that I kindly updated with the current logo, and I took off K-12 to just say Student Discipline. Some of the main changes we made, we just removed, there were numbers next to the incident types that referred to the student code of conduct. We just made sure that we removed those numbers to try and make it a more evergreen form and that they aligned with the student code of conduct. We added a line about midway through the first page that this incident includes stat or circ, just so we are recording that data. And then if you go continuing down that page, about 3/4 down, it says, did this incident include a room clear? Check yes. This is our way of tracking room clears, and you will see that in our proposal later under room clears. It goes on to say, who is the incident reported by? What is the narrative? What happened? What are actions taken? Where did the action, what action was assigned? All sorts of data, including signatures by the administrator, the person filling out the form, and a parent or guardian. This, like I said, is essentially your current referral form that we are now proposing that we use. Our hope is that this becomes a digital form that lives on what is now the staff intranet, so that way staff, just like they fill out other forms like the workplace injury or the e-pay form, could fill it out there and then it could be sent to the admin at their site in order to track data and to have a central collection of data that is included.
Thanks, Katie. And as I said, I just want to reiterate again, it was even said at this table earlier that consistency across the district is helpful, is key, and that is what this form is about. And I'll say, in our bargain in 2019, thank you. In our bargain in 2019, which was 5 years ago, which is wild to think about, but 5 years ago, we were talking then about needing consistency across buildings in terms of discipline. During my time in BEA leadership, we had been talking with administrators about the need for consistent discipline across buildings. This is not a new problem, and this, for us, having a written form is the next step in providing that consistency for our staff, for our students, for our families, so they know what to expect, they know the expectations they are being held to, they know what the next steps are. Okay, I'm gonna move on to 3B, the reentry conversation. This is very, very similar language to what y'all have in 3A3, your A3B, follow-up support. And this is essentially very similar to the language that we had in our last proposal about a reentry conversation. We did reinstate our sentence at the end, stating the intention of this conversation is to restore the health and feeling of well-being to those impacted. And just as a reminder, that is put there because there, I think, has been a misunderstanding of the term restorative practices, restorative conferences, and so we just want to define what is the purpose of this meeting. The next section there is on room clears, where we are reasserting much of our original proposal. There is the definition of a room clear and the reporting of the room clear in the aforementioned form that Katie just walked us through. I do want to reference in the BSD proposal, there was a reference to reporting safety incidents at their worksite to the Worksite Safety Committee. And we had a conversation about this in our team, and I wanted to share a couple of things about the reason why we have struck that language. Number one, many safety committees talk about things like traffic patterns, talk about things like, hey, watch out, there's a drip over here, don't stand on chairs, things like that. In the few incidents that I have heard of where they're reporting student behavior to safety committee, and you'll forgive me because I cannot remember the specific school name, but the recommendations of the safety committee were, I think I can say, absolutely ludicrous. What I remember reading in the minutes to that safety committee were something along the lines of, a student threw a stapler and it hit me in the chest. And the response, the recommendation was from the safety committee was, please don't turn your back on that student. Which I think is, if you've been in a classroom with 30 students, nigh on impossible. Another thing that I remember from those safety committee minutes, a student threw a chair at another student. Make sure to remove objects from that student's reach. Again, thank you, great. I cannot do that. So the safety committee was for us just not a solution to this problem.
Can I make one comment on that piece?
Absolutely.
Not necessarily disagreeing with your conclusion, only to say that OSHA has made it really clear that that the safety committee is supposed to be reported to about student incidents of safety in the classroom. So I don't necessarily personally disagree with you about whether the safety committee is the proper entity to be addressing those types of issues. But because of a variety of OSHA actions against school districts where the safety committee, it was not reported to the safety committee, student interactions in classrooms that cause a safety problem, that is now causing school districts to react or respond by directing things that way. So I've made very similar comments to OSHA, like, do you realize who's on the safety committee? And that's maybe not the best entity to be addressing these issues, but OSHA's been pretty clear on that one.
Thank you, Brian. I mean, to your point, that was another thing we wanted to raise, which is in our sort of informal surveying of worksite safety committees across the district, it seems that sometimes the membership of the committee doesn't actually represent educators. It is sometimes like a school secretary, a school custodian, an administrator, which if traffic safety and spills and, hey, don't jump on chairs, kids, is your goal, totally makes sense. But if we're gonna contemplate this language, because I take your points well taken about OSHA, we will probably need to consider language that actually spells out who's on those committees.
And I don't remember off the top of my head if do we have language in the CBA about safety committees, or some contracts do? Yeah, again,
We don't, but that's a good idea.
I made the same point about membership, typical membership of a safety committee and what that committee is designed to do. So, your administrators probably know better than I who and how people end up on safety committees. Oftentimes it's people who are willing to serve, not necessarily educators being excluded, but it's like who's willing to serve on those safety committees. So.
That's why I was on a safety committee, not gonna lie. They were just like, anyone? And
Yeah.
people raised their hands, that was it.
Teachers are part of the safety committee, at least my experience has been, and I think, yeah.
And I wanna be, I don't think, and stop me if I'm wrong, Emily, I don't think we're trying to prevent the reporting of it. Like, we're not saying absolutely do not. We're saying that is not a solution to providing recommendation. Like, telling me to not turn my back on a student is not a recommendation that will work in a classroom. Okay, I think. What did I say? I think for the rest of the article, we are in agreement. So it's just that 9A, which is a big section. That's the only part where we're not in agreement.
Can I just, following up on that, ask for clarification? The conversation that we just were in about the safety committee, was that in response to the district's proposed language on page 2 under follow-up support, where it says the administrator or designee will report safety incidents at their worksite safety committee meeting? Is that what you were responding to?
Correct, just explaining why we did not include that in our counter.
Got it, thank you.
Can I ask a clarifier?
Oh, I'm sorry, did I jump in?
Sure. Appendix G that goes along with that, are you gonna present that as well?
Great question, Janine. We do not have a counter at this time.
Thank you.
Hi, I have several questions, if that's okay. Okay. So I was wondering if you can clarify your meanings as it pertains to centralized and alignment. So I'm getting a little bit, and that's on me, getting a little bit confused on that. So this provides alignment, right? Something like this would provide alignment so that we're all gathering the same type of data, and it can be formatted and we can like desegregate it in a uniform way, right, which data should be. And I appreciate that. But so now the difference with centralized, it's where it's housed, is how I'm thinking about it. Housed at the district level, housed versus housed at a school level. What is your intent as far as centralized? Because I get clear alignment, but where would this be housed?
Thanks, Joanna, for the question. We'll get back to you after a brief caucus.
Okay, perfect. And I was also wondering about not including students that are dysregulated. I'm looking at section A, number 2, and I'm reading through it really quickly and just, hopefully I'm not wrong here and point out if I am, but I don't see a student being accompanied or removed from a classroom with someone that can see where they are going if they are an immediate threat, which to us, that's the biggest concern. Like, if a student is posing particularly more than a disruption, that's one thing. But it causing an immediate threat, being alone in the hallway is my biggest concern for me. And I know that calling the office happens, right? And hey, the student has left, or I've sent a student to the office because of this immediate threat. But to me, it's more like I need someone to come pick up the student now, right? And then someone attending to that, that's what happens in my building because the student needs to be had eyes on. And it could also be part of their individual safety plan, that if they become that dysregulated, that it poses an imminent threat, that they be accompanied. So I'm wondering where that can fit within this section and if you guys had discussion on that. And I think it's important to kind of get to that so that we're able to propose something that comes from where your intent is starting at, if that makes sense.
That totally makes sense. We have had a lot of discussion. I just want to make sure I'm representing the team correctly, so we'll come back to that as well.
Can I just chime in on that
Yeah.
last point? I don't know if I'm adding much here, other than to say, it'd be great to kind of just hear back from you guys intent-wise instead of just specific language. I don't know that in the end, we necessarily have that big of differences of opinion on this topic. I don't sense that your team is saying, if we have a student who's posing a danger, it's good to just set them loose in the hall and hope they end up at the office. I don't sense that to be your team's intent. So I feel like this is one that we've kind of talked back and forth at, and we've proposed different language. But it has to be possible for us to resolve this issue, because I don't think it should not be an insurmountable issue to come to an agreement on when is it wise to send a student somewhere and when is it wise to make sure you have assistance to do that. So I would just encourage us to have that conversation and not get too lost in the specific language. It would be just good to hear your perspective on the topic.
I like that better. I guess, how would it look like? Is really my question. How would it look like that a student not be alone in the hallway when they're posing an immediate threat? And a suggestion maybe on that, not necessarily your intent, because that's totally on point. Like, nobody wants a kid that's super dysregulated out in the hallway on their own. They can cause harm to others themselves. Like, that's not what I think anybody wants. And then I'm also wondering about this form. This is something that the district uses? Is that correct?
The date on that, when we got it, the last time it had been adapted was 2017, but I can tell you with certainty that is a form that has been used in the district since at least 2005 when I started. Now, whether it's recency of being used or not, I'm not going to talk about, but that is definitely a district form.
This is a district form?
Yep.
Okay, good. I wonder if we're talking about kind of like an aligned form, if there's a potential of collecting room clear data within a referral on its own, as opposed to it's two different data collections. Like, if there's a behavior and it resulted on a room clear, that can be combined I can see it combined as opposed to taking two different, I think it's added work if we have two different forms.
Joanna, if you look on the first page, about 3/4 down the way, it says, did this institute include a room clear? And that's why we have strucken that part from our language and just said it's part of this form now.
Oh, okay, so it can be combined, it's great.
Yeah, that's the intention.
Perfect. And then I think the last thing, like, as I'm thinking through it, because I love systems, something that, like, it's something that we're going to a good direction with that. And MTS, there's a lot of work with our MTSS that aligns with our strategic plan. I'm just thinking about timing wise, and maybe you guys can have the discussion of that. Maybe this isn't even the right place to bring that up, and you guys can guide me, my team and your team through this. But this is the work that I believe needs to be done if we want alignment from a committee from across the district, which is the MTSS, and support something like this. So if we, at some point, let's say we agree on, like, yeah, that's the work that we should do together, do we have to pause the ratification or the acceptance of language because that's going to be in its work? How does that work? Should I even be asking this? Does that make sense? Should I not ask this question?
No, I would say that frequently in bargaining, we assign something to a joint committee that's going to come back with an outcome. So I don't think it necessarily would have to pause this process. I think the question is, what's the right venue to collaborate to come up with this type of a document? So.
Are there any other questions about Article 9? Okay, then the next article we have is 11.
Do we have another one? Here, we can have this one.
Veronica, do you need one or do you have an extra?
I think they need.
No, we're good. You're good? Okay. Thank you.
Everybody has one, right? Good, all right. It's me again, hello. Not on cardstock, should have started with this one first. Or some of them are keeping me on my toes. Okay, so moving through Article 11. I think the first, hang on, I'm so sorry. The first area that we are different is in A5. Y'all had proposed shifting an hour of time back to administrators for that professional development time on our staff work days. And we have gone back to current contract language. Our members rely on that individual work time because as we all know, there are far too many things to be done in a normal work day. So that extra time is vital, and we want to make sure that we maintain that for our members. Moving on down to our new addition it's not a new addition, we had language in our last proposal about developing a calendar for professional development each academic year, and I am going to talk about that. We changed this language a little bit because we want to make sure that our intent is clear. What we are asking for is we want to make certain at the outset of the year that our members know what days are district-led professional development days, what days are for worksite-led professional development, and what days members can choose what PD to attend. And here is the reason why. We have many folks, for example, elementary music teachers who are at buildings and they are sitting through a PD in their building about teaching students how to read. That is great and valuable PD. But for a music teacher, that time would be much better spent working with other music teachers to talk about things related to a music classroom. The same goes for a lot of our singletons who are in buildings who don't necessarily need the professional development that's being offered that morning. And what is happening now is they're like, oh, hey, there's professional development opportunities for you during the latter half of the day. So you can spend your work time if you want to go over and hang out with music teachers or Japanese teachers or CTE teachers, whatever. You can do that in the latter half of the day. As I just mentioned earlier, our members rely on that work time, and thinking about the opportunities that we are providing for our staff who are classroom teachers versus our staff who are those singleton teachers. We want to make sure that we are not saying you have to give up your work time to go to a PD that is meaningful for you while everybody else does not. So we're just looking for an equity of professional development there, and we think that the establishment of a calendar so folks can be thoughtful about, oh, I need to be in my building for this particular thing, great. If it's something that maybe I can go to a different building, let's just have that be consistent. Again, there's that word consistency. Let's have that be consistent across the district. So the folks over at Fir Grove are doing something where the music teacher can't leave while the folks over at Shoals Heights are doing something where the music teacher can leave, that doesn't provide an equity of opportunity there. So that's the intent behind that language. We have struck your proposal around a possible late start or early release. And we spent a long time talking about this, and where we landed is there are so many unknowns around late start and early release. We have no idea what that might look like, when it might happen, and so we don't want to put language in our contract. We would like to entertain that as an MOU if and when that becomes a reality, so that we can be more thoughtful about what is actually happening in that moment, instead of trying to guess what might be happening and then have that in contract language. So we just don't feel it's appropriate to put here now until we have much more certainty around it. We have put back in, under parent-teacher conference, we have put back in the CTP and ACE, and this has been a practice for the last few years. It has been great. Our CTP and ACE educators have let us know that they need these conferences, they need this time. And so our feeling, again, is that since this has been common practice, we've signed MOUs for it the last couple of years, let's get this in the contract. And if there are changes that need to happen that are the exceptions, then let's have MOUs for that instead of coming back and signing MOUs for what is already happening on the regular. And then moving down to section C, we are agreed on 1. And number 2, we came back to our language around tying make-up days to required instructional hours set by ODE. That just provides more certainty for our members, provides, there is a goalpost, and we don't want that goalpost to move to like, oh, if the district thinks we should make up days, we'll make up days, versus if we are required to make up days, I know what to expect. So we're leaving that in there for that additional certainty. And I think there's a page on here for art, if you would like to doodle. That is the end of our proposal.
Did you have any questions on Article 11? Okay. I'm gonna guess that we're probably gonna break for lunch and caucus. I do have something really quick that I wanted to bring up before we go into that, if that's all right. We were surprised, my team, to not see 18 and 19 on the agenda. And we were wondering if you had the intention of bringing that back to us at some point today. And I ask that because we know that we have many members who are waiting for that information today, if possible, to make their final open enrollment decisions. And so we were surprised that it wasn't something that you had planned on bringing, at least at the beginning. So we were wondering.
When you say people are waiting, you're talking about the Article 19
Correct,
portion of it, yeah.
specifically about the insurance, yeah.
Yeah, and I mean, I think Mike can chime in on this. He probably deals with it more than I do. I mean, we do tend to look at those things as working in concert because they're kind of the core economic pieces. So it is difficult to have one without the other. You know, and honestly, we're kind of trying to decide where to go right now overall on economics. I mean, I think we remain fairly far apart on that topic. So I don't know that we've resolved ourselves, you know, what our next move should be on that topic.
Okay. So I hear difficult but not impossible on making sure that they go in tandem. So what my team is willing to do is to spend our first caucus to work on a MOU draft to propose something that we could move forward for specifically Article 19, if you are interested in that.
I mean, I'm always interested in proposals that you guys have, so, you know.
Okay, then that's what we will work on.
I would just add to that as we look at COLA and as we look at benefit rates and including those, then we're also costing Article 10. We're over $150 million there in terms of what the ad would be. So as Brian mentioned, it's hard to know where to go next because we've got so many dollars on the table. And so what's the priority? What should we be looking to, if that makes sense?
Thank you.
Okay, so I believe lunch is there in our room, Ponderosa Pine. So you can go through. So do we want to, how long would you guys propose that you would like to have for your caucus?
I would guess probably at least an hour.
Okay, check in with you then.
Yeah,
All
thank
right,
you.
thanks, Suzanne.
Thank you for coming back really quick. We just want to answer it so you guys can continue your work on 9, which we appreciate that you guys are working on that. So a couple of responses, and I hope that we're able to answer the questions that came forward, and if we missed something, please just let us know. The first one, we felt that there was some questions specifically around our declining the language around shall seek assistance. We're not opposed to assistance, and we think that you guys might think that we are. We're not opposed to seeking assistance. We're not opposed to assistance. What we are opposed to is making those phone calls and assistance doesn't come. Assistance isn't available. The phone isn't answered. We are asked to wait. And in those situations where that phone call is made, we in those classrooms or those environments have to make real-time decisions. And that sometimes we have to make a decision that can't wait for that support or that assistance. There are also situations where safety plans have been written for some of our students that would allow them to, in what state they're in, to take breaks wandering the hallways. So there are that. We wouldn't necessarily call that sending a student to the office that's dysregulated, but we are abiding by some safety plans that are written with some language like that. We do make a point that was brought up is that we have students that elope from an environment without permission, and that phone calls and radio calls are made to alert whomever we need to alert that that is happening. We also use radios and phone calls to notify the proper people that a transition is being made when in our judgment that student is able to make that transition on their own. Even in a dysregulated state, we're not talking actively, but where an option to, do you need to take a break in X space, brings them down enough to be able to make their way down. Phone calls or radio calls are used to let somebody know that that transition for the student is being made. Does that help?
I think it does, but what leaves me wondering is like, how could we articulate that in a written format? I guess that's what I'm struggling with. Like, how do we can't put all of those examples in there, right? So how can it be worded in a way that lives here and acknowledges all of that? Because all of that is true. We live it every day. And I don't know how to put it there where my only concern is an extremely dysregulated student being sent out where they can get into an altercation in the hallway. We're trying to find them. They, even on their way out, say things like suicidal tendencies, and they elope and leave, and nobody was able to get to them. Like, that's what worries me. And I rely on the judgment of our teachers, our staff in the building to make those decisions, right? And I want to honor all that, but how do I do that in a language? Would you suggest?
Well, I would suggest that in the judgment of the member, because you just said what we're trying, there are so many moving parts to some of these situations that we do have to make those decisions in the moment. And we can't write down or capture every single situation or circumstance that could arise, because in 20 years, I'm still seeing new ones, right? So I think that if our administrators and management do put the trust in their educators to make those decisions, then that's how it is written in the contract, in the judgment of our members. Thank you. Yep. I also just want to clarify that, like you were saying, though, with an extremely disruptive student that would not, in our judgment, be a candidate to be able to transition themselves without support, those, we would not send that. I cannot imagine the situation where somebody would think in their judgment that is an appropriate thing to do. However, the difference between sending a student from our classroom to the office or to a different space versus a dysregulated student leaving our space without, in that moment, right? They're eloping. those would be the phone calls that we would make to seek assistance. And I think if anybody is, currently works in a building, you probably would find yourself where there are staff members positioned all throughout the building to find the eloped student using the systems that we have in place at the school. That isn't a situation where a student would have been sent from the room, but where they would have left unattended or unsupported. I apologize, I said teacher judgment. Bargaining unit member judgment. A couple of other things. There was an alignment versus centralizing question that Emily's going to go ahead and answer.
Good, it's on. Okay, can everyone hear me? Great. So I just want to give you credit for asking a very astute question. We enjoyed sort of parsing this out in our caucus. I'm not being sarcastic. So basically, I would say that it's not an either or, it's a both and, right? Yes, it is aligned, and yes, the form will help ensure meaningful data fidelity, all of that. For us, centralized means that it lives on the staff intranet, or as we put it, BSD's digital infrastructure. And we think that there are good reasons to do that. I think that the argument we keep making is that centralization of data of this nature is one of the more effective tools we can think of to guide meaningful support and an understanding of root causes in a way that may not be possible with a limited perspective of just a work site, right? And so through centralized data collection, we will maintain clearer understanding of what the trends are, or at least better questions to ask. And then hopefully better supports for the students, because what our overriding concern here is that, behavior is communication. What are our students telling us about what they need? How can we do this in a systematic and thoughtful approach, not just the sort of parochial approach of in each school its own island?
And I think maybe the final question that you guys had was in regards to the safety committee language being the place to bring some of these situations, or that's where we would report them to. We're not opposed to having imminent threat or extreme disruptive situations brought to the safety committee. What we are opposed to is that recommendations and decisions made about how to handle a situation would come from the safety committee. We do not feel that that is an appropriate place for our educators to receive that kind of response. Let me make sure I got the right words down. Actions, solutions to whatever problems that were being reported, that is not the appropriate place for those to come from. But in terms of reporting to, we're not opposed to the reporting to, or that that's a place where it could be discussed, but that is not the place for it to be solved.
I have no disagreement with that. And also just to clarify that my understanding of what OSHA wants is us to report student behavior situations that result in injury. So other student behavior situations don't need to be going to safety committee, but it's only ones where somebody was actually injured.
And we can agree to that, yes, same.
Okay, thanks.
Can I go back to the centralized part? So you mean the form to be centralized, right? Not the information.
Oh, no, we mean the information as well.
You mean the information?
Yes, the form and data collection analysis, yes.
Oh, okay, got it.
Were there any other questions that you guys had in regards to Article 9 that would be helpful in your work?
I don't think so. I think your answers, this discussion has been helpful.
Okay,
so
good.
We've been talking about it, so I think that will help us start to gravitate towards some counter proposal.
Okay, thank you.
Yeah,
Thanks for that time.
Yep, thank you.
passing it out?
I'm dead. Yes, here it is.
And this is the.
Oh, okay. Oh, mine said as well.
So,
Our mics are not
here, why
working?
don't you take this?
Oh, you want that? I don't need it.
But if you might need it, comments.
Yeah.
Right?
I was just saying, thank you, yes, but my mic's not working.
They're all off.
Okay.
But they're all out of, they're all
Fair,
out of
fair,
battery.
we knew it was coming.
This is back now. Hey, Matt, this one's working.
Does it work? Everyone have Article 9? Got it, okay. So,
Hold on a second.
You
are
need
there
extras?
extra Article
Yeah.
9 somewhere? There's some needed over there?
No, Brian's right there.
Thanks.
I'll give one over there. Okay, so for the sake of trying to make up some time here, I'm gonna kind of go through this quickly. I'd ask for any assistance. I think I've caught all of the significant proposals, changes, differences between the two. Differences between the two. But if I miss anything, please don't be shy about helping me catch it. So Article 9A1, I think we have agreement down to, we made a slight change to your proposed sentence there, that last sentence there, just around administrator maintaining a record of written feedback, simply because most of us do that through electronic, so it isn't about producing the written record, it's more about just maintaining what we receive. We accept the new title for A2, but to maintain the consistency of that paragraph, we propose adding the word extreme, just because the piece speaks to extreme student disruption. Further down in there, we maintain the idea of seeking assistance to escort students, but hearing your concerns around that, you can see if you just look a little bit further down that paragraph, we added or proposing to add a new sentence in there around if assistance is not available, the bargaining member shall use their judgment about next steps to maintain student and staff safety. So trying to catch that idea. We did maintain that additional sentence as well. We just feel like it's important that when a student comes back, even if the full sort of follow-up supports are not yet in place, there at least needs to be some exchange of information of what occurred after the student left the classroom. So we left that sentence in there. Next page over, we're accepting for the most part your recommendation around the room clears paragraph. Which you can see there. I think the real, or maybe the most important piece in there, other than just the definition, is that last sentence of the first paragraph. Bargaining members will report room clears via a student conduct form, and you can see that we reference that a little bit later, an idea that you all are proposing around a place to report room clears. And let's see, then the next paragraph there under 3, again, this is previously proposed language, but you'll notice that we're not accepting the idea of 2 hours of extended contract automatically on a room clear, but certainly support is needed, and that could look different in different scenarios. We've already agreed on the administrative support, that first paragraph there being eliminated, but if you go down to 4A, we're proposing that this paragraph not be labeled, use the term referral. And it is not to try and avoid any scary terms or administrative responsibility. It just simply isn't an accurate term to use. This morning we looked at the student code of conduct, and in there, it was rightly pointed out that the term referral is certainly used, but that's only in the case of level 3 and 4 behaviors, and we need a system that can allow a teacher to report any level of behavior, so limiting it to simply the use of the term referral, at least in the BSD, would limit it to only level 3 or 4 behavior. So we think a better way is just simply to describe that paragraph. So we came up with this proposal around reporting student conduct. And you can see the paragraph there. Most of that is simply accepting previous language or your proposed language there. The very last sentence there we think is important. Again, had a lot of talk around this consistent reporting form. We're accepting that idea. We do think that should be accessible via a district electronic infrastructure like intranet or something like that. We do like the idea, though not referenced here for maybe for further conversation, is that form should be developed through the ongoing MTSS work that's been launched and some sort of committee where that group can develop that. The form that was proposed earlier, as we talked, we all know it's a very old form, lots of problems on that one itself. We think jointly a much better form could be developed. Paragraph 4B, we're asking to maintain the language around the title there of follow-up support rather than re-entry conversation. 2 reasons. Re-entry, the term re-entry, the connotation there is that something must happen prior to re-entry, or that these things should happen prior to re-entry, and sometimes that's possible, sometimes that's not. And the term conversation, we actually like the term support more because it's more than just a conversation when this occurs. You can see there that we basically agreeing to a lot of the language there, all the way down to the last half of the last sentence. I don't recall, and I won't read the language that you actually initially proposed. We're simply recommending that we use the same language that's used in the very opening paragraph of this Article 9. We just basically did a copy paste of that concept. And then the very last piece down there, we had a lot of conversations around this whole safety committee and its role. We kind of came to the conclusion we agree. So why even have reference to safety committee here? That it plays a different role rather than the follow-up support for students who are removed or leave a classroom. And then the last page there, I believe that we are in agreement with everything here and that there's no proposed changes. Pending any questions or comment?
I just want to mention that for 4B, the follow-up support, we didn't actually lift the language from the preamble. We did reword that. This was related to your language, trying to look for maybe different language from restorative conversation or restorative practices. And so that is a rewording. It's not exactly the same as the preamble, but it is trying to get to, I think, the concept that BEA is supporting as well. You want me to?
Thank you. It's just a follow-up. I heard you mention that it's not written in here, but the form that we presented, you're not interested in that, but you are interested in a joint task force to create a consistent document? Is that what I heard?
Yes, that's our position. I don't know if that'd be called a task force or a subcommittee to MTSS or whatever the terminology we'd use, but some sort of joint work to develop a form better than that old form, yes.
Okay, just because it's been a long day and we just want to be crystal clear. So it's not something that's housed through the MTSS process, but it would be a subcommittee where both parties would appoint members
and they would be in conversation with the MTSS process.
Right, we just see the MTSS process as is more than just that, but a comprehensive look at tiered support for students, one of which would be reporting behavior and intervention around or responding to that behavior. So that's probably the best group to make sure that the form that we develop to use is in support of the larger scope of the work.
And who are the members of this committee? Who is on this group?
Oh, I don't even think it's been established, someone who's doing it maybe.
It's basically, it hasn't been established, we're just saying that's good work for them to start, because we are starting an MTSS system district-wide, but it's not anything that's done yet. But that would be great, because it would align all supports, because in the end, like you said, all behavior is communication, and I think everybody agrees to that. So in that sense, when you think of MTSS behavior for supporting kids, we want to align it and not create something that's over here and not talking to this. So that, it's just right now, we discuss it as what a great work for a committee to take on.
Okay, I mean, heard, and they would definitely have some expertise. My only concern is, as a bargaining agent, this is something that impacts our members' working conditions as it provides for, greater student safety, responsiveness to students. So we do need voice in that process. We do need members on that committee, however constituted.
I think that's it for questions for now. Thank you.
Thanks.
Want to talk about next one?
I know that it's 4:00. I have a couple of date proposals, just to throw your way so that I can give your guys' team some time to think about it. Sorry, let me flip back to the right page. I do want to say that we appreciate you guys wanting to meet sooner than the dates that we had proposed, so we were very enthusiastic about that. The dates that we were hoping for would be August 22nd, or September 10th, or September 12th. All of those evening sessions, we would like to propose a 4:30 to 10 timeframe.
Can you repeat those dates again?
Yep. August 22nd, September 10th, or September 12th.
Thank you.
Yep, you will note that we have opened up our days to not just be Thursday dates, to try to get as many as we can on the books as quickly as we can to move our progress along.
Okay, thank you for doing that.
Our team will look at it and get back to you.
Thank you.
Okay, yeah. So we'll see you on the 10th?
Yes.
Did you have locations for those, or is that just to be determined if we end up?
We're open to either. Our space is open for all three of those, but.
Okay. Okay.
And it could be more than one of those. It doesn't have to be one or the other. It could be all three.
Yeah.
All right, thank you.
Go team. Yeah,
We did have
Sorry.
some good news for you.
Yeah, sorry. I do want you to know, we have spent a lot of time working on Article 10 because we do know that within Article 10, as well as others, lie answers to your priority questions. So we have spent a lot of time working on 10, and we do plan to present that the next time to you, so you will see that.
Great, thank you.
Okay, thanks.
Thanks, Ryan. I just.
Thanks, guys.
Ryan. Okay, see you later. Not Ryan. Yeah, that was good. Efficient.
What choice did we have?